All right, the recording has started.
Okay, thank you. This is Janet Hurley, Chair of the Land Use Review Board. March 20th, 2025. I am calling this meeting to order with a board roll call first. Kirsten.
Kirsten Saltan, member present.
Alex.
Alex Weinhagen, board member present.
Brooke Dingledine, board member present.
Sarah Had.
Sarah Had, board member present.
That is all 5 of us present remotely. Thank you. The first item on the agenda is opportunity for public comments on non-agenda items and any receipt of correspondence that board members may have gotten in terms of public comment. Do we have any public that would like to comment?
Yes, Chair Hurley. I'm Kevin Anderson. I'm actually a member of your staff. I joined today, perhaps mistakenly, hoping I'd catch some of you in the flesh to introduce myself here in the Montpelier office. I'll just say that I'll look for an opportunity to do that at a future meeting, and it's good to see you all again. And I might tune back in for some of the Tier 3 discussion later this afternoon.
Okay, great. Thank
That's
you,
all.
Kevin.
Hi, Kevin, and just know that we will be in person at the Montpelier office in one of our April meetings. But we're happy to see you now, even though it's remote.
Great, thank you.
Actually, we're going to be in Berlin rather than the Montpelier
that's right.
office.
Not the Montpelier office, but in
Right.
proximity.
Yeah, and we'll serve you lunch too, Kevin, if you come to that
All
one.
right.
Okay.
Okay, thank you.
Yep. All right, so consent agenda, review and approve the March 13th minutes.
I'll make a motion that we approve the March 13th minutes as drafted and or with any minor revisions we might discuss.
Okay, great.
I'll second.
I'll second. Oh,
I'll
withdraw my-
seconded. Sorry, seconded by Sarah first. Okay, any discussion or corrections on the minutes from the 13th? They were perfect, Brooke. Okay, no discussion, hearing no discussion, seeing no hands up. All those in favor of approving the minutes of the March 13th, 2025 meeting of the Land Use Review Board, please say aye. Aye.
aye.
Aye.
That was 5 ayes from all 5 board members. That is a unanimous decision to approve the minutes. Next, we have discussion of appeals, enforcement, and attorney-client memoranda. Brooke, I believe you wanted to amend that a little bit in terms of making a motion to go into executive session.
Sure. So I will make the motion for the enforcement, appeals, and attorney-client privileged communications, the premature public knowledge of which would be prejudicial to the board or others. But I would also like to amend going into executive session by adding an opportunity to talk about employee issue under the executive session exemption of 1 VSA 313 A3 and 4 covering discussions regarding employees.
Okay, do we have a second?
Sure, I'll second.
Any discussion? Hearing and seeing None. All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
Sorry, my microphone was off.
And Brooke is an aye.
Okay, that was again 5 ayes. That was a unanimous decision to enter into executive session from which we will return to this meeting potentially around 2:15. Thank you. Stay tuned.
Oh,
You're muted, Janet.
Sorry, I said hello. Are we recording, Maddie? I think we are. I just got a message. So
Yeah,
I
we're
think
good.
okay, so we can continue. Let me get back to the agenda. I see all five board members are present. So we're coming back from executive session where we discussed 2 enforcement matters. And now I'm not remembering, is it Alex and Brooke have a couple of motions that they would like to put forth? Or one each?
That's right.
Alex,
Yeah.
do you want to start?
Sure. So I move that the board authorize enforcement staff to transmit an administrative order regarding case number 2023-10.
I'll second the
have-
motion.
Thank you, Brooke. Any discussion? Seeing none, all those in favor of this motion, please say aye. Aye.
Aye.
Aye.
Aye.
That was a double aye, Alex and Brooke at one time.
Brooke is aye.
So that was 5 ayes from all 5 board members. That is unanimous. That motion passes.
Okay, then I would like to make a motion that we authorize enforcement to issue an assurance of discontinuance in case number 2021-01.
Second.
Any discussion? Was that an assurance of discontinuance on that one?
Or an AO.
Yeah.
Oh, or an AO?
AOD.
Okay, okay.
AOD, yeah.
Oh, okay. So, okay, any other discussion? Seeing none, all those in favor, please say aye. Aye.
Aye.
Kirsten, aye.
Brooke is aye.
Alex, I.
Okay, that is 5 ayes from all 5 board members. That motion passes unanimously. So we are about 30 minutes over on time. And I think at this juncture, I would like to ask the board if there is one of these 3 remaining items that we feel we could put off till another meeting. Perhaps the first one. Meeting
I can also
discussion.
slim down the tier 3 one to be less time. Doesn't need to be an hour, I don't think.
You think half an hour would do it?
I think so,
Okay.
yeah.
Okay, then let's proceed. So, discussion of meeting procedure is the next item on the agenda. And this is a sort of carryover. Do we have what, Alex?
Who's leading on this one?
Yeah, maybe it was me, and I feel like I'm fried. And I wouldn't mind putting this off until next time. So if everyone's okay with that, I would not mind.
I'm totally fine with that. I just wanted to also mention, in terms of the tier 3 discussion, some of the question points that Alex has mentioned, I don't feel like I'm completely ready to provide full input on those yet. So
I don't think this will necessarily be the final chance. Do you, Alex?
Talk about it when we get there.
Okay.
Janet,
Yes.
also on, if we're going to punt meeting procedure to a future agenda, were there documents that you wanted to share on that in advance that might help frame that?
Let's say that there will be. You and I had found some and discussed them a bit, but then other things popped up and I never got to them in the last week and a half. So I'll try to make good on that for when this comes up again. So discussion of 1 versus 10 acre checklist. And this is something that came up because the town of Moortown had questions about the use of this checklist to get them on the 10 acre list versus 1 acre list for Act 250 jurisdiction. And the board wanted to hear from council before we discussed it and perhaps made any kind of decision on whether to move forward to continue using this checklist in any way, or whether to discontinue it or replace it with something else. One idea is that, you know, perhaps we should not be recreating the work that others are doing in the administration, and ACCD keeps very close track of municipal bylaw adoption procedurally and dates and whether they're meeting their statutory, you know, requirements and adopting those bylaws. Perhaps this board could rely on ACCD's determinations and data concerning that through their municipal data center. But let's open this up to other board members to put forth their thoughts on the matter before making any kind of decision on the matter. Sarah.
So I think this policy and procedure of the LURB predates some of the changes that happened to 24 VSA in the early 2000s that require municipalities that are adopting regulations to file those with ACCD. And so ACCD does have a warehouse of them. I think there still probably is a missing piece there where one of our staff would have to look through that list and make a determination. Yep, these are 1 acre versus 10 acre towns. But I'd like to see that when a municipality submits that information to ACCD, that sort of informs the process and sort of alleviates a burden on the municipality to duplicate those efforts. I think it also sort of streamlines that process and relates to some of the things that we've been talking about in terms of information intake with the regional plans and how they sort of then impact ACCD in terms of the designations. So there's just a missing piece for me there. I'm not sure how we address it right now, but I am for moving away from this prior process and trying to look to have a streamlined process.
Any other board members? Alex?
Concur. As a former municipal bureaucrat, what happens in order to adopt zoning and subdivision bylaws is robust. And I agree with Sarah that ACCD is keeping good track of which municipalities have adopted zoning and subdivision bylaws. So I think we can lose the checklist entirely and rely on the list that ACCD maintains. I don't think the checklist, there are a whole host of reasons why the checklist is very problematic, but I don't know that we need to, I don't know that you need me to go through all those. I think ACCD's list is sufficient.
And before I give the floor to Kirsten, I just want to add that it typically, you know, except for our larger towns with, you know, more sophisticated staffing and or just more staffing, it's often the RPCs that are uploading this information to the ACC website and providing this information to ACCD and keeping track of all of this for each of their member municipalities. So even very small towns with very few staff are at least getting assistance from the regional planning commissions on these matters. Kirsten, go ahead.
Yeah, so the checklist has been, put in place through NRB Council. And it's been my understanding that these are the specific like content and details and process that are the elements of, duly adoption of bylaws. And I'm just wondering if we don't collect that or verify that information as part of a review of whether or not a town is 1 acre or 10 acre, as happens occasionally, where else in the process does that detail occur? I mean, it sounds like ACCD, and they do have that municipal database, which I've seen. They have the library, if you will, of all the bylaws. But not my general understanding is not all towns necessarily engage with an RPC. Like where in that process is there verification of the specific content and that the required procedure has been met? Like if we don't do that, where else does it occur? That's my question.
ACCD does it. ACCD does it. Sarah, go ahead.
I was just going to say it's statutorily required of the municipalities to provide that to ACCD. So if they didn't do that, their regulations would be out of place. So they're statutorily required to file with ACCD. They're not statutorily required to file with us.
When you say file, what does that mean?
They submit all of the information. They submit the bylaws. They submit, when they held their hearing, when they were adopted, they submit various evidence that their bylaws were duly adopted. ACCD keeps very close track and in fact contacts the RPCs on a regular basis before they review the municipal planning grant applications. They review whether that town has its duly adopted bylaws and there may be a requirement at that time to look at whether they have zoning bylaws, subdivision bylaws, flood hazard and river corridor bylaws. They look at all of that and they keep track of which towns have what and whether they're in unified status. So they keep track of all of that. They keep track of town plans, of course, too, but we're not asked to look at town plans in this matter. But in any case, they do. If they see something that doesn't look right, they ask the RPC to confirm, or they go directly to the municipality. Sarah, go ahead again.
I was just going to say that I think Janet raises a really good point, is at some point, ACCD is reviewing this, maybe as part of that municipal planning grant process. I don't know if they have a list and how frequently that list gets updated.
Every year.
Okay, so it sounds like there is a list that ACCD can generate once a year at least that we can rely upon to then bring it over to our side and have that be used to make a determination about 1 versus 10 acre towns. Maybe we do that annually. Is that?
Well, actually, they do it even more often. Whenever there's a change from a municipality has to send it on up the chain and the ACCD updates its data. And it's just that every year the grant administrator contacts RPCs and municipalities about any questions or discrepancies that she might see in terms of whether someone has duly adopted bylaws. So. Go ahead, Kirsten.
So just to be really clear, I completely understand that these bylaws are transmitted to ACCD with information and that ACCD is compiling that and keeping it up to date. But I'm still not clear on who reviews the specific content of the bylaw in of itself, the different elements of the bylaw as to content and standard that would be, would meet the minimum requirements under the standards in place for a duly adopted bylaw. Like where is that occurring in the process, if not within, part of a jurisdictional review? My general understanding is that, the RPCs and ACCD used to have a role in this review and verification of whether or not a town had attained 10-acre status, and that has no longer occurs. And so that function and role has fallen on the NRB to do that more in-depth review of the specific content in a bylaw as part of determining if the town goes on the 10-acre town list. So if someone can help me understand that more granular piece of it, that would be great. If anyone, I know you all have these deep backgrounds in municipal planning and zoning, and I appreciate you walking me through this a little bit more.
Do you have a response to Kirsten? Okay, go ahead.
Yeah, so Kirsten, I think you're raising a good point, and I don't want to paper over it. I think what Sarah and Janet and I are saying is that the adoption process is very well documented by ACCD, because towns are required to send copies of public hearing notices and their adopted bylaws and a report on how the bylaws actually do conform to the statutory requirements and the municipality's plan. So all of those documents are forwarded to ACCD, and that's why ACCD's database is really the best for documenting who has adopted subdivision and zoning bylaws as well as municipal plans. But no one is doing what you're talking about. No one at ACCD, as a matter of course, is walking down the required, pieces of a zoning bylaw per the statute and evaluating whether town X is compliant. That does not happen. And so I take your point that, in order to make a determination about 1 and 10-acre towns, you would like that to happen. I don't think that is necessary to make that determination. And I'll give you just one practical reason why. The legislature changes the statute about what is required in municipal zoning and subdivision bylaws almost every year. And many municipalities, there's portions of their zoning regulations are no longer compliant with state law. And in those cases, those zoning bylaws are not invalidated. It's just the specific sections that have been trumped or updated by state statute that have not yet been updated that become, old and no longer in use because there's a section of
Severable.
state statute. Yeah. And this is a real thing. This has happened recently because the legislature has been tinkering with municipal zoning in order to address the housing crisis and requiring certain densities and all of that jazz. So what I'm getting to is that it shouldn't be our purview to nitpick over which sections of a zoning bylaw do or don't meet the statutory requirements if it's in a duly adopted zoning bylaw that is in fact in force. Unless we as the Land Use Review Board want to call out maybe, some smaller subset of those provisions that we feel is critical for that determination of a 1 versus a 10-acre town, which we haven't done. And what the municipal checklist does that I think we need to jettison is it looks at every provision. And what would be the recourse if a town I'll use my old town, had a telecommunications regulation in their zoning, which they're not allowed to have under state statute if those projects are being reviewed by the PUC.
That's not true.
Right.
Well, that,
They can have
that,
it. It's
You-
just
you-
not, it's not it's not used unless the PUC, unless it doesn't get a certificate of public good, but
look at
that's
the
sort of a
checklist,
side,
and
side
a
question.
reasonable municipality who looked at the checklist would I think come to the conclusion that their zoning regulations were not in conformance if they had those provisions in them.
Right.
But
Right.
in any case, I think my point is, you're right, Kirsten. Nobody at ACCD, as far as I know, is going through a very granular review. They're checking to see, did you have a public hearing? Did we get a copy of the regs? Did they file the report where they addressed how it meets statute? But are they actually looking at every little provision for compliance with statute? I don't think so. But I don't think that's necessary.
Yeah. I concur with that. Go ahead, Brooke.
I hear what Alex is saying, and but I think there's a huge difference between, if you have duly enacted zoning and subdivision, you get on the 10-acre list. It doesn't change just because state law changes and your floodplain regs aren't exactly the way they should be or whatever the thing is. But I do think that having some acknowledgement, inquiry, decision at Act 250, I think that's important. Maybe not this checklist, but as a practicing attorney, I have 2 cases that I can think of where there was great confusion. One was a zoning administrator told my clients, you don't need Act 250 permit. So they built and then had to go get an after the fact thing. So having like an actual list at Act 250, because we're the authority with jurisdiction over this, I think that that's a good idea, as opposed to, even if it's assembled by somebody else, having that resource on our thing. And the other thing I just want to mention is, what's the purpose of the 1 in 10 acre division? It's about jurisdiction. And if zoning isn't up to snuff, or subdivision regs are not up to snuff in a particular town, that's why, the whole purpose is we want to protect and regulate development. So if we don't have effective zoning, that's why Act 250 is triggered, right? If it's more than 1 acre. So I just think we do have some responsibility to be a clearinghouse or some checklist or something. I don't know.
Yeah, Brooke, I agree that we should have a list. I totally agree. I would suggest that it should be by reference to the list that ACCD maintains and spends lots of time and doing. I don't think that we need to be a check in terms of whether that particular zoning regulation is up to snuff or not. In part because if you read what the statutory requirements are, they're general, and we could spend an awful lot of time arguing about whether one provision is adequate in order for it to be a 10-acre town and have less Act 250 jurisdiction. I'm going to show my past, bias and say, I think that we're all in this together, municipalities and the state of Vermont, and we should give deference to municipalities that are on a list established by another state agency as having adopted zoning and subdivision bylaws, and leave it at that, with the understanding that any aggrieved party can appeal a JO, or, if they feel that some community zoning is so far out of whack that it shouldn't be a 10-acre town. But I think we should give deference to the municipalities.
I'm not sure I agree with deference to municipalities, because this is the very basis of our jurisdiction. So I'm not 100% aboard.
I hear you.
May I ask why? I think I hear the both of you saying that you're wanting the same thing, that we should have our own list.
Let me explain a different case that I was involved in the past. We argued criterion 10, and the Regional Planning Commission argued against the applicant, claiming that the town plan was inconsistent with the regional plan, even though that very Regional Planning Commission approved the town plan and checked off the box that said it was in compliance with the regional plan. So I've encountered a Regional Planning Commission that became a party and appealed to the Environmental Division, claiming that criterion 10 was not satisfied. We ended up winning, but that was troubling because they were a party and are a party to appeals to argue things like this. So it's like, who needs to make these decisions? I think it's us.
Yeah.
Even if it's based on ACCD. Like right now, is there any difference between our list and their list? Is this like, are we searching for a problem here?
There
is there?
there is for Moortown right now.
Well,
You know, and just to respond to something Brooke just said, that happened between Manchester and the BCRC at one point when I was the planning director there and the chair of the BCRC. So these things happen. But with Act 181, there is a lot more collaboration now between the towns and the regional planning commissions. We're going to be approving those regional plans. We're going to be looking at whether those regional plans are truly reflective of their member municipalities' plans to some degree. You know, I think what Act 181 tried to do was bring these things together and to be more efficient. I mean, I don't know how many times this might come up, but even reviewing one set of bylaws can take some individual person maybe over a week to go through that kind of, to comb it through at the detail that checklist requires. And most towns don't have anyone on staff that can take that kind of time to fill that out. Who's going to fill that out? Is it going to be us? I think our current legal team is not interested in doing that. And I think that it makes sense to defer to the ACCD municipal database. Kirsten, go ahead.
Yeah, I guess I'm kind of more with Brooke on this whole topic. I think if no one, I'm curious, I'd be interested to see like what would be typically contained in the report that goes to ACCD that sort of outlines compliance with the standard, and if there's a disconnect between, the evolving standards that are in effect within bylaws under evolving statutory requirements, I feel like that could be addressed as a policy topic. If at a point in time you meet the then standard and thereby the town became a 10-acre town, so be it. So I think this is this goes beyond Act 181. I mean, the status of 1 or 10-acre as it has been so foundational within Act 250 with respect to defining if you're a 6 or a 10 lot town or a 1 acre, 10 acre for commercial is really critically important. And there definitely needs to be some opportunity for checks and balances if a developer or an interested party disagrees with the determination. They need to have, so it should be taken up as a jurisdictional determination topic, and they happen so infrequently. We might have like 1 or 2 a year. To me, it's like, yeah, it takes time to go through it, but then, whatever that determination is, it'll be in place for, a long time moving forward. It's not going to be something that we have to keep redoing. So I think it's so important that it deserves this kind of attention. So that's kind of where I am.
Kirsten, you
And I'm
say
happy to
maybe 1 or
continue.
2 a year?
Yeah, I mean, I don't know if Peter Allison or, might have some further context for that, but I'm kind of like, well, we have this in place. You know, what it does, it has worked. I mean, has it been perfect? No. I mean, what is, I would advocate that we definitely need to maintain a list that is a resource that everyone can go to look at what's the status of this particular town, and that we have some responsibility in verifying, you know, that information when that determination is made. And we really don't want to have a disconnect between, you know, LURB publishing a list and then someone comes in and asks for a JO, and there's a disconnect there. Like, we should be doing this whenever a bylaw update occurs and we're asked the question. Typically it comes in through a local official. Like, hey, we now have subdivision. Are we now a 10-acre town? Can someone please confirm this? But I'll let others.
Yeah, I'll just say, it is a very rare occurrence. I would say 1 to 2 a year is, on the high end.
So, oh, Sarah, go ahead.
I just have concerns that our list could be out of sync with ACCD's list, and we're creating a void between the two, where there are a bunch of towns out there that have duly confirmed plans and approved plans, and regulations.
You mean bylaws? Yeah.
Yeah, bylaws, regulations that are not being duly noted as being changed within potentially the Act 250 realm. I do think that there is a missing piece, and I think we're all can perhaps agree on not having duplicative process that could potentially create discrepancies. However, I think the key piece that I'm hearing is there needs to be someone, Act 250 needs to approve the list from ACCD. We need to come up with a process where that information is then looked at, reviewed, and yep, that's good enough for us. I'm not sure that we can do that or change the process in this meeting. I don't know, Janet, in terms of expected outcomes from this meeting, if you're looking for somebody to start work on drafting revised guidance, or just to try and send this into a productive next steps.
We are, even though we jettisoned one agenda item, we're now 15 minutes over and Billy is waiting. So, actually, I think that's a good suggestion, Sarah. To, well, maybe there's disagreement yet, though, on whether to jettison this checklist. I feel like it needs to be jettisoned. It's overkill. But in my opinion, Sarah, go ahead.
If Kirsten's amenable, what I'd love to do is to have her and I work with either Pete or one of our legal staff on this offline, and see if we can come back with something that works at a future meeting.
I would be happy to do that.
Pete?
Yeah, that sounds good. I was just going to say, I want to make sure we've got clear direction. We're happy to help the board formulate what it decides, but and I'm happy to work with Sarah and Kirsten on a direction there for proposed for the board.
I think that's great. I do wish, however, that the checklist could be removed from our website ASAP.
And just for the record, it's a resource right now. Are you wanting to remove that resource for towns?
Yes. Yes.
And
Yes.
is that a full board decision, just to be clear? Yeah.
Yeah, we can have a motion on it. The reason is that I think any rational municipal official would look at the checklist and construe it as something they needed to comply with. When if you really read it, there are so many provisions that relate to areas in which a municipality cannot regulate or cannot discriminate you know, you can't infringe on the ability of someone to have a home occupation, for example. And that is entirely irrelevant to our role in the Act 250 process. So there's just a lot in there that I think is not helpful
relevant. Yeah.
as a guide or relevant. And if that's what it's intended to be, is a helpful piece of information, I think it's doing the opposite.
Yeah, I agree. Jenny, you had
But I don't
your
want
hand
to, I don't
up.
want to fall
Yeah.
on my sword here. If you guys want to work together and we can put this off, I don't think any municipality is going to lose their minds in the next few weeks if that checklist is still there. I just personally would like it to come down.
Yeah,
I'll just flag that under the open meeting law, we have to keep all of our guidance published online. Well, something we could do in the meantime would be just flagging it and saying that the process is currently under review and that people seek advice in the meantime.
okay.
And the checklist is separate from the certification process.
Yes.
Yeah, and I don't think the checklist is guidance, right? It's not a formal guidance document of any sort, is
No.
it?
Guidance is anything written down.
Oh, okay.
Well,
Is
yeah.
But
there-
it seems
I won't fight that.
also that it's unclear as to whether this program is using that as guidance right now. It's like, it doesn't seem that it's clear to me at all how this program intends to use that. And so perhaps it would be a good idea right now to make it clear how that checklist should be used, if at all. I'm not comfortable with that checklist being used.
Yeah, and I'm not sure what the right administrative protocol is to draw this to a close. So I guess I'll just make a motion that we no longer utilize or publish this checklist.
Do we have a second on that motion?
Can I make a friendly amendment to it?
Sure.
Which,
Sure.
which I would like to go with what Jenny recommended in terms of
Flagging it.
just to make sure that we're legally on the up and up, that we flag this and outwardly to the public, and if you would give us the authority to work on something to come back to the board with, so under consideration. I think we can get this together before we have another town that we need to act upon. So hopefully that will satisfy your concerns.
Are you good with that, Alex?
Not really, but I want to be collaborative. So I'll withdraw the motion.
Okay.
Yeah, why don't we just keep going and figure it out later?
Can I just ask one more thing before we entertain any other motions? And that is, have we made a determination for Moortown, Pete?
No, so that I just wrote that down as one thing to flag for you all before you close this topic. You have not made that decision. Again, Moortown utilized the checklist as a resource. They submitted a certification and they noted that they did not that they had a town plan that was out of date. I think that's the general facts there.
Which does not invalidate their duly adopted zoning and subdivision.
My understanding under statute that just because your
So-
plan is out of date, your zoning regulations continue to hold the force of law.
So I would entertain a motion to approve Moortown's 10-acre status, if anybody's willing to do that.
So moved.
Okay, any second on that?
Yeah, I'll second.
Okay, Kirsten, you have some comments?
So discussion, yeah, has someone reviewed Moortown's submittal? It sounds like we've reviewed it at least with insofar as that they had flagged there's no current town plan, and I can appreciate that wouldn't invalidate bylaws, but has someone reviewed the other elements of whatever's been submitted?
They
They-
submitted the
yeah.
checklist, correct?
They submitted the checklist. We have not gone through and verified any of the submissions on the checklist, and but they did also submit their certification that they have gone through and certify that it's duly adopted subdivision and zoning bylaws.
Brooke?
I don't feel that we have properly agended a vote on any specific determination of 1 versus 10 acre for Moortown. I think our agenda indicated we were going to have a discussion on a checklist.
Okay, that's fair. Are you willing to withdraw that motion, Sarah?
So just a preliminary question, I guess, too, is to just back up is, does it require an action of the board?
Maybe not.
Yeah, I was going to say there's not any process that would require action of the board, and in fact, it was again just a self-certification under the process that's outlined on our webpage. It was brought up as related to the discussion on the checklist.
So do you,
I'll
is it
withdraw the
you that,
motion.
okay. Never mind then.
We clearly need a process, so thanks, Sarah, for volunteering to move that forward with Kirsten's help, because this is getting a little silly. And if we're telling municipalities that we want them to self-certify, and then when we do, they can't simply be added to the list, which is all that's happening, then the process is broken.
All right, so I don't think we need a motion or for a couple of board members to work together in collaboration with our legal team and Pete to get something back before the board to consider at a later meeting. Does that sound like a plan? Okay. Sorry, Billy. We're ready to move on to discussion of tier 3 now, if you're still with us. But Alex, do you want to go ahead and set the table for this one? Oh, you're muted.
You're muted, Alex.
Thank you. Sorry. Yeah, happy to. And if possible, Janet, if you'd allow me to drive a bit on this agenda item, just in terms of recognizing people, it might go faster. So this is a follow-up discussion to the presentation on Monday, and I have a short time horizon in order to start engaging stakeholders, at least initially. And so I wanted to make sure that there was time for the board to ask questions about what you heard on Monday, and also provide any suggestions about things you heard on Monday. And then I have some specific questions for you that I put in that email, which as I know Kirsten's comment earlier, maybe you haven't had enough time to sort of stew on them, or you want to talk some more before you make an answer. But I'd like to start with asking if you had questions, if there were things about, for example, the 6 resource areas that Act 181 compels us to consider as possible tier 3 areas. And if you don't have any questions about those 6 areas, if you had any suggestions about other resource areas that you feel this process should consider. That's my opening question to the board. Go ahead, Janet.
just because of some feedback that or input that we've gotten through some of our public meetings in the last couple of months, repeated input and other events that some of us have attended, there seems to be a concern that prime ag soils, prime statewide important ag soils are falling through the cracks, that the legislature is sort of letting that fall through the cracks, that there seems to be from our Agency of Ag an urgency about this, that I wonder if we want to consider adding prime ag soils to this list for consideration.
Got it. I think that's a good suggestion and one worth talking about with the stakeholders for sure. Sarah?
So, thought just for discussion is in the same legislative session that created Act 181, I think there's Act 121 that was specifically pertaining to river corridors, floodways, floodplain, and comprehensively sort of a statewide look over ensuring that there's a baseline regulation on all those areas. And I'm wondering how far we need to go. And I think if we do include river corridors on this, I'd want to see that we try to be in concert with those efforts as opposed to running something parallel that didn't fit well. So I think that's just something to offer. And I know a lot of that's occurring in Billy's wheelhouse, and we'll defer to him to sort of help inform that. But that was just a thought to share.
Excellent. Thanks for that comment. I think it's instructive to know that in the 6 resource areas that that Act 181 did identify that we had to consider, river corridors being one, wetlands were not listed. It's clearly a sensitive natural resource, but the legislature chose not to require us to consider it. We still could. It's our discretion. But I'm going to read into it a little bit to say that it probably wasn't included because we have a robust wetland protection law and permitting system. And so, there could be duplication if development in or near a wetland was an Act 250 trigger. Go ahead, Brooke. Oh, Brooke.
You're muted,
You're
Brooke.
muted, Brooke.
Forests.
Okay.
I mean,
Forest
forest
as a-
blocks, forest blocks is something different. I mean, that requires some, big area typically when you consider that, and whether it's significant as a block, whatever. But I don't know. I mean, part of what we were listening to about ag is ag and, management of the forest seems to be going hand in hand. Many of our farmers are now managing forests. I don't know. It was just a thought.
Just to be clear, your suggestion is that we should be thinking about forests in general as a potential resource area to consider for Tier 3 designation.
Or forest
Okay.
blocks.
Well, even if it's not large enough as a block, or I mean
Okay.
blocks for sure, but sometimes, you have areas that are just not big enough to qualify for that kind of protection.
Okay. This is good. Anybody else have questions or suggestions about the 6 resources we must consider or others that aren't listed? Go ahead, Janet. Oh, you're muted, Janet.
Sorry, accidental hand raising.
Okay, no worries. Go ahead, Kirsten.
Yeah, so I do feel like I need more time to kind of ruminate on all this. Um, I've been thinking about just, that we're doing this mapping that will define, at least at a point in time, whether or not Act 250 is implicated for these critical natural resource areas and exactly where they are. And I know I'm interested to understand to some extent how fixed some of them are. Like, um, is the mapping going to be subject to change over time? Do we want to kind of say, okay, here's this map that's sort of fixed for 5 years, and then or a process for updating? So this is sort of as each critical natural resources under consideration. In my mind, that's also considering what complexity may be part of it, dealing with that sort of administratively. So I'm kind of interested to dive into that a little bit. I know, ANR has the river corridor rule coming out, and I'm interested, or that's under development. I don't know if that's really underway yet, but maybe Billy, I would love to hear more from ANR about, all of these more specifically, what ANR already does or doesn't do. When we met on Monday, Billy might remember I actually had mentioned to him also 9B soils in terms of like at least the highest value ones, like the number one. These are like incredibly valuable for agricultural productivity. That there's the scale of anything from important farmland rating 1 to 7 is recognized currently as a 9B soil in Act 250. But maybe like the highest value ones would be something we might look at. I've also thought about, I guess I'm not remembering, and maybe Billy wants to fill in, but like riparian areas, does that include lake shorelines necessarily? And I think about the undeveloped shoreline areas within Vermont as having particular importance. I mean, as we look at all of our lakes and ponds, some of them are already more highly developed. And of course, deserving of some, we've got the shoreline protection rule, but then we've got ones that are far less developed and um, more tend to be more rural areas. And I feel like those, principally undeveloped shorelines would be something we might look at. And then I also think about like the higher elevation lands. I think about the sort of administrative side of this too, like what's straightforward to administer. That's sort of a bright line. I know we've already got the location-based 2,500 feet elevation, but maybe as part of this, we just examine like the higher elevation lands, and maybe that kind of transitions from north to south across the state. Like, how does that overlay with other important or critical natural resource factors? Like, I'm kind of in my mind, like in trying to hone in on what are the greatest value. I've thought about, well, might you layer, like, if an area has more than, a few of these features in play, that would also have this cumulative importance. And I don't know if you or Billy want to talk about, the other existing ANR mapping tools like the BioFinder, how, if there's a relationship between that and this tier 3 mapping that we're doing. So this is kind of still kind of higher level. I love the optimism and enthusiasm for getting a rule drafted by June. I think that's really ambitious. Because I feel like we're going to have lots of conversations about all this and bring in, like I know you're organizing all the stakeholder meetings, but for the board too, it's a lot of detail that we need to consider.
So let me
So
respond
those are
real
just kind of
quick.
my conceptual, like a little bit all over the place, but
Yep, that's good. I appreciate that. Let me respond real quick, and then I want to give Billy a chance if he wants, and then go on to Sarah. So part of Act 181 was to charge ANR with updating natural resource area mapping and to have a protocol for doing that and have it be scientifically based. And so I'm quite sure that the legislature's intent was that this board would determine what resource areas would become tier 3 but A&R's responsibility is to keep the resource area mapping up to date and based on good science. And so I think we will continue to work hand in glove, over time, even after we've designated our first our first slice of tier 3. And we're likely, I think the intent was that we're likely supposed to be pointing at their data so that as their data is updated and made better over time, our tier 3 designations flow with that. We'll see, but I don't think we want to have a static map. But a couple other points. So I know he can speak for himself, but I know he's working on a document that addresses some of your questions about what the state already regulates within some of these resource areas and what those permitting processes already look like. So I think as Billy gets that ready, we'll have more information for you on that front. And then when you say higher elevation areas, higher elevation lands, what I need a little bit more from you, Kirsten. What elevation are you talking about? Like, because 2,500 feet and higher is already jurisdictional. When you say higher elevation lands, are you thinking like 1,500 feet and higher, or 1,000 feet, or you're not sure?
I mean, so 2,500 feet and higher is jurisdictional for certain things. It's not jurisdictional for everything, by the way. If you look at the statute, I think state and municipal purpose is not expressly listed. I don't have it in front of me, but yeah, I don't know what a number might be. And maybe it's a different number as you move from north to south, but could just take like, and it also probably goes hand in hand with looking at habitat connectors. But just that maybe there are some ridgeline areas that emerge as critical natural resource areas, looking at through the lens of elevation, that through this mapping. I don't have a number specifically, and it is pretty coarse, like what we have now, 2,500 feet, statewide. Southern Vermont is not the same as Northern Vermont. And I think we have an opportunity here to be more refined in the scientific mapping. By the way,
Check
Billy,
that.
thank you so much for joining us. And thank you for driving all the way down to Rutland on Monday. Really appreciate that.
Yeah, thanks, Kirsten. And I want to give Billy a chance to speak up. So Billy, if you want to say something, go for it.
Sorry, I'm on my phone. I was planning on just listening in, but thank you. Yeah, and happy to be there in person and make the trip down to Rutland. It was great to see you all. I think as Alex said, we're trying to get to the bottom of a lot of what you were asking and talking about, Kirsten. I think our goal is to really tease out what of these resources already have some level of regulatory oversight outside of Act 250, which could easily have more protections through permits outside of Act 250, just so everyone in the stakeholder conversation understands what's already happening or could easily happen to protect these resources outside of the Act 250 process. So that's some foundational work we're currently undertaking and should have ready in a couple weeks to feed into the stakeholder process. The only other thing I'd say right now is like what you're talking about in concept is interesting. I would really encourage you to think about what's going to work in practice. Act 250 jurisdiction is already incredibly complicated and hard for people to navigate. And I think you would know as well as anyone, Kirsten, what goes into some of these jurisdictional opinions. So really, for a jurisdictional trigger, having really easy to identify bright line things that people know whether they're either in or out of is, from my personal perspective, an important thing to be thinking about. And things that aren't necessarily super dynamic, things that are relatively static, so people can plan and make investments that are long-term in nature based around those lines and aren't concerned that they might change in a year or 2 or 5. So those are things I just encourage you to think about as you're contemplating this further. But yeah, we definitely are going to provide lots of all of the mapping resources we currently have to the process as needed. That assessment of existing regulatory oversight or the opportunity to tweak some of our existing regulations to address protections of these resources. And then, as Alex did say, Act 181 charges ANR with maintaining, creating and maintaining uh, online resource maps based on science and a process to update those. We were never resourced for that work. There was never any funding or positions associated with that. So we put that request into the legislature this year as identifying that as an unfunded mandate. So hopefully we will get some resources for that. But until that happens, that's not something we have the capacity to do at this time.
Thanks, Billy. Yeah, Sarah.
I was just gonna say, and this goes, I think back to when we were talking about shorelands, how much thought there was back in 2014 when the state went to that sort of first ever in time statewide Shorelands Protection Act. There's a lot of history here behind forestry blocks is another one. And I think as you move forward, will be best to use established terms such as forestry blocks as opposed to forests, and give deference to some of these other areas that have been really well thought through. I think as you alluded to with wetlands, there's a lot of jurisdiction behind wetlands already, perhaps left out for a reason. There's so much thought and intent in shorelands and what's covered, and there's already a state permitting process for that. I just want to be very cognizant of wherever possible, not reinventing the wheel, using defined terms, and looking to existing processes in place for protection as part of considering, do we need to go above and beyond those existing processes?
So that
That's
is a great
certainly the
segue.
approach. Yeah, that's certainly the approach we're taking, Sarah. So thank you for articulating that much better than I just did. But that's how we're approaching this, and hopefully can just acknowledge that a lot of the resources identified in the act are sufficiently protected already, or with some slight tweaks can be through those existing permit programs. And then kind of, is there something left for Act 250 to focus on that maybe has fallen through some of those gaps. So thanks for saying that so articulately.
So that's a great segue to a specific question that I wanted to ask. And I don't want to assume everybody's agreeing with what everybody else is saying, right? So I want to ask the question. So for resource areas that do have existing state permitting and protection via other programs, do people agree that those do not need to be tier 3 designated areas in order to trigger Act 250 jurisdiction? I'm getting the sense that generally, Sarah, you would be in agreement with that, but I'm not sure about Brooke or Janet. Go ahead, Janet. Oh, you're muted.
You're muted.
I think generally, yes. I think I need a better understanding of all of those permitting programs. So maybe that's another board training, Billy, that we could ask your agency to provide some of us.
Sure. And Alex has seen like a very early draft of this, but what we're trying to do is for each of the 6 enumerated resources, try to define them. If there's existing statutory definitions in Title 10 or elsewhere, or in NRB rules or whatever, basically define what they are, provide some sense of their scope and location on the landscape through existing map data, and then articulate what existing regulatory programs exist that either directly protect them or could be slightly modified to further protect the resources that have been identified in the act. And then try to identify, like, given all that, what gaps might exist. So I think once we have that, that will probably be a great resource for you all to start with. And then
Okay.
if there is the need to do a deeper dive in any of those regulatory programs, we can certainly provide that.
Brooke,
That would be really useful, because I think the answer to your question, Alex, is it depends. I mean, I am also not a fan of duplication of effort and want to keep it, as Billy said, as practical and uncomplicated as we can. But yeah, I don't feel competent at this time or prepared to be able to understand it without seeing the analysis that Billy's talking about. I think it's a task, it's an issue by issue exercise in my mind.
super helpful feedback. Kirsten, do you want to chime in?
Yeah, I kind of feel like Brooke does. I feel like, yes, conceptually, if something is already otherwise protected, that, there is value in the 250 process in general, but in through the lens of what we're talking about here with the, tier 3 critical natural resources. But I don't want to just say, okay, well, this is already protected, let's just sort of jettison it and not have it in mind as maps are being developed and looked at. I think you still want to have like the general landscape understanding of what are the resource features if once we're honing in on areas and specifically on the mapping. So I think we want to retain some of that contextual information. And I look forward to hearing more from ANR about its analysis of the degree to which it interprets that it already otherwise protects, all or like these areas or portions of them. So
Okay,
that's
great.
kind of where I'm thinking.
Excellent. Sarah, I kind of spoke for you, but I don't want to do that. So I want to give you an opportunity to chime in on this yes or no question, agree or disagree.
No, I think you got it. I'll just
Okay.
say for the sake of time, thank you.
Okay. Great. I'll try to wrap this up since we're over. The other question I had for you, which is a general one, but we're at the front end of this, so it's good to ask big questions, right? Is the breadth and coverage of tier 3 areas and whether any of you have given any thought to what that ought to be. I have, but I maybe I should tell you what my thought is. I do not think it was the legislature's intent, not all of the legislature anyway, to have 80% of Vermont be a tier 3 area. I don't think that was the intent. And as you saw, hopefully from Monday's presentation, if you took just those 6 enumerated resource areas that we have to consider and define them at least as best as ANR has, it would cover 80+% of Vermont. So my question to you is, I know nobody's going to have an actual number, but I think there's a lot of fear out there in the community that is what tier 3 is going to do, that it's literally going to paint entire towns as tier 3 areas where any development in that town will have to go through Act 250 review. And I would love to get a sense at the front end if each of you feels like that's inappropriate or appropriate. I don't think it is appropriate. I think that we need to be more circumscribed about the areas that are going to get this designation. What do you think? Go ahead, Janet.
Oh, I didn't have my mute on. So I started talking and you can hear me. So I think that the other thing that Act 181 said was we need to make sure that we're not overburdening any municipality with too much tier 3. And we also need to look at the relationship between all the boundaries we're going to be drawing in terms of the tiers and environmental justice focused communities, and that we want the benefits and burdens of the state land use policy to be as equitable as possible. So I think I agree with you. I don't think the intention was that 80% of the state would fall under tier 3. It, I think the way you're thinking about this makes sense.
Thanks, Janet. Kirsten?
Yeah, I agree with what Janet just said. I never envisioned that it was gonna be some, large percentage of the state. Like,
Okay. Brooke?
I'm withholding any comment at this point. I don't think that's necessarily a way to, I mean, I think that's looking at it result oriented, and I don't think that I don't have any expectation. It's going to be fact driven for me.
Fair enough. Spoken like a legal thinker. Fact driven. That's straight out of your profession, Brooke. That's why I said that. Not as a ding at all. I like the term. Sarah?
I'll come at it from a little bit of a different angle. I think we should be doing some test drives and some checks and measures as we go. And it would be very curious to me as we start to plot through. I think you had already done your presentation on Monday. That sort of like less than 0.5% of Vermont is our designated downtowns and things of that nature. It'll be curious once we start getting these areas identified in terms of overlaps. And I think that could be used. We can develop some sort of testing methodology, because I think if we're finding that these tier 3 areas are inclusive of what we're also thinking are going to be our tier 1A areas, I think that. So I think to sort of walk the line between, I think those sort of generalizations in terms of it probably shouldn't be 90, the other like 99.5% of Vermont. And to Brooke's comment about, well, it's sort of, we don't want to be arbitrary and capricious about how much or where we say, but I think we can maybe develop some bright line testing where, it common sense wise should not be these areas. I think that would be a way to perhaps go about the end that you're seeking.
Good job, sort of equivocating on the question. But your point is super well taken, because this issue that Janet raised that was in my presentation about not disproportionately impacting municipalities with the tier 3 designation. If you actually read the statutory provision, it's not quite that. It's that you won't disproportionately impact municipalities in their I forget the wording, but in their ability to have tier 1 areas, right? So it is actually tied to the tier 1 areas. If we were to have tier 3 areas that effectively made it impossible for a community to have tier 1 areas, that's what the statute says we can't do. So it's a really good point.
Yeah,
Kirsten,
that's what I was
Kirsten.
just gonna say.
Oh, okay.
Like the fact that something would be tier 3 may exclude it from being tier 1A or B. So
Right.
you're not going to have both in place at the same time, in my mind. Like,
Right. We would want to avoid that for the most part. Okay, so Annette, I see your hand up. I just want to make sure that I've gotten board input on the items that I need before we open it up to public comment. Actually, I think that's it. The other item I wanted to talk to you about was the stakeholder engagement effort. And I think I have ideas on that, and I've talked to some of you about some of them, but I think we need to wait on that, if for no other reason than we're running out of time today. And it does sound, and I want to respect all of your desire to see that information from A&R. And that's a little ways out. So my grand ambitions to have stakeholders in a room, in early April, probably not going to happen. Probably got to push that a little bit. because what I don't want to do is I don't want to walk into our stakeholder meetings and our public engagement and tell them that the board really doesn't have an opinion about this yet. Like it's a wide open palette and everyone gets to paint it however they see fit. I would like to walk into those meetings and say, here's what the statute requires. Here's some direction from the board, and now we want your input because we haven't drafted anything yet. And so I'm sensitive to getting your input before we start that engagement process. So Janet, can I turn it back over to you as chair, and you can acknowledge Annette or any other members of the public?
Sure. Annette, why don't you go ahead with your question or comment?
So my comment is related to what you were talking about. If the chat was turned on, I would put 2 links in. Is it possible to turn the chat on?
Might be best just to email those to us.
This discussion has been going on for a while in terms of increasing ecological protections, and I'm going to channel former district coordinator Ed Stanek here. He has for quite a while saying that we need, all Vermont Supreme Court decisions have said we need bright lines. And Ed has been recommending a 1,500-foot elevation trigger. As a result of that, and because we have this fellow who does fabulous mapping, he has given us really good maps. One of them that I want to share with you simply shows the square miles and elevations above 30, up to 3,000 feet, above 2,500 feet. So it's a really good image in one place. The other map shows if there was a 1,500-foot elevation trigger, what towns would be most affected by that. And there are about 12 or 13 towns. And then there's, in that same file is another map that combines a whole lot of the different forest blocks and habitat blocks. So I will, if you want, who wants to get the 2 links? I just threw those maps up on our server, so I can just send you the 2 links. And
if you want to email them directly to somebody, I would suggest Alex,
okay,
and that
I'll
since
send them
he's
to Alex.
spearheading this. Okay.
And then
Thank
if
you.
you'll share them with the rest of you, I think that it's simply a useful tool to help envision. And then we took 2 towns, we took Underhill and Danby, and looked at what would happen and I asked him to do Danby because I'm familiar with Danby, and I'm not sure why he chose Underhill. But in both cases, that 1,500-foot elevation trigger would actually protect the areas we want protected. In other words, that those are the areas that we would want to call out. So it's a very interesting exercise to do. And if you do it in a town you're familiar with, it's worth taking a look at that, because Ed is right. A bright line in terms of a jurisdictional trigger is a whole lot easier to address. And we have all this mapping stuff, so I'll send you what we have. And the other thing that sort of contradicts this is that urban forests have value. And that's an aspect that we've overlooked as a state, but there is an urban and community forest program as part of Forests and Parks. I think it's more focused on, community forests that are owned by towns, but there are a lot of important urban forests that serve a lot of functions. If you do a search, you find studies and papers that show the functions that they perform, including minimizing pollution and all sorts of good, beneficial health things in